Intro to the judicial branch. The basics of our judicial branch is that we have a dual system. Just like federalism, we divide the power of government in between federal and state. There are federal courts and state courts. Now, we will focus for the purposes of the AP exam on the federal court. Um, Now, the federal court, out of all of the cases that are heard in the courts, the federal court hears about 2% of cases. So 2% of your trials and appeals are heard in federal. Most of the work of justice is done at the state level. There is criminal and civil law, and the federal courts handle both criminal and civil law. Criminal law is used when a person has violated the laws set, particularly in this case, by the federal government. So any violation of federal law, Commerce Clause, interstate commerce, taxes, anything like that, treason is going to go to the federal system. Civil law is used to settle disputes between people. So if we had an issue about a will, or there was an issue over the rights to land or copyright, whatever, that would be more like civil law. Only 3% of cases are ever go to trial, and most cases are settled out of court. The federal court system is divided into districts and then circuits. Districts are the lowest level of the federal court system, so lower district courts. Each state has at least one district. The larger the state, the more districts it has. Like you can see, Texas has 4 districts here. Texas is a big state. Virginia is divided into 2 districts, so we have 2 federal courts in the state of Virginia. And then the federal system goes to the next step is the Circuit Court of Appeals. We have 11 different appellate courts, like circuits, and then we have a few in DC. So the Ninth Circuit, for example, would be everything from Montana to Washington to Alaska, Arizona, California. Our circuit is the Fourth Circuit. That's everything from South Carolina, North Carolina, Virginia, Washington, Maryland. I No, I think Delaware is in the third. Okay, so let's make that a little bit more clear. The organization of the federal court. Okay, so at the very bottom, you have your district courts, your lower district courts. This is the lowest level of the federal court system. There are 94 district courts in the 50 states and the territories. They are the only court where you will see your typical trial. 2 lawyers, witnesses, and a jury. Okay, they're at each federal courthouse, depending on the size of the district, there could be anywhere from 2 to 28 judges, and there would be a U.S. attorney in that federal courthouse. They hear civil suits, bankruptcies, maritime cases, naturalization, like becoming a citizen, and violations of federal crimes. So, for example, Michael Vick, when he gambled, didn't pay taxes on his gambling, he had a gambling ring in multiple states, violated interstate commerce, he went to the federal court in Norfolk because he broke federal law. When the Somali pirates and the ones who raided Captain Phillips or took over Captain Phillips' boat, or ship, the one that the movie was about, they ended up in Norfolk Federal District Court. Now, just above the district courts, you have the Circuit Court of Appeals. The Circuit Court of Appeals is kind of like a court that you've never really seen before. It's in between the Supreme Court and the District Court. There are 11 circuits, and then there's one in DC, so there's 12 altogether. When you go into a Circuit Court of Appeals, you don't see one judge, a jury box, 2 lawyers, witnesses. What you see is a panel of judges, and all the panel of judges do is review the cases, the appeals that come from the district court. So if you don't like the way that the district court jury or judge has ruled on your case, and there is a violation of some liberty, constitutional right, then you can appeal, and then the circuit court will hear your case, and it's judges sitting there reviewing it. Now, the top of the federal court organizational pyramid is the Supreme Court. A Supreme Court, they are also a panel of judges. There are 8 justices and 1 chief justice. This is the court of last resort. If you don't like the Circuit Court of Appeals decision, you can then appeal to the Supreme Court. Let's talk about jurisdiction. Jurisdiction, by definition, is the right to hear a case. There is 2 types of jurisdiction. There is original jurisdiction, and then there's appellate jurisdiction. Original jurisdiction are the first courts to hear a case. If you have original jurisdiction, you have the power to hear a case for the first time. Original jurisdiction is when the court is going to assess and decide a case based on the facts of the case. So if you think about it, the trial, the district courts, the trial that they put forward, that's the first time anybody hears that case. The facts behind the case, your lawyers are arguing it. Original means first. Okay, appellate. Appellate jurisdiction means that this court has the power to hear a case that has been appealed. The court interprets the case as it is related to the law. They don't hear any new facts. They don't hear any lawyers. There is no jury. So your district courts, again, they have original jurisdiction. This is the trial. The litigants appear before the court. The federal district courts primarily handle cases that involve federal law when somebody breaks it, and they go before a judge and a jury with the lawyers arguing. Court of Appeals have appellate jurisdiction. Like I said in the slide before, you can't just appeal a case based off of anything, just because you don't like what the jury at the lower district court has to say. There has to be some violation of the Constitution that requires a panel of judges to review the facts of your case. Courts of appeal only have appellate jurisdiction. Supreme Court. Now, the Supreme Court is unique because it has both original jurisdiction and appellate jurisdiction. So the Supreme Court is the first court to hear a case if there is a problem with an ambassador or a foreign dignitary, or if the United States has a controversy with another state. All right, so that in those 2 situations where a state is suing the United States, or in that situation, the Supreme Court can hear it. Or if there's a foreign dignitary, and they go before the Supreme Court. Now, most of what the Supreme Court hears are cases that are appealed to it. If a case is appealed from the lower federal courts based on a question of constitutionality, the Supreme Court is the court of last resort. They will hear it. They also have appellate jurisdiction where cases appealed from state courts. So state courts handle over 90% of the cases. If there's a federal concern in that state's decision, then it could end up in the federal courts and could end up in front of the Supreme Court. But most of what the Supreme Court hears or has the power to rule over are cases using their appellate jurisdiction. Okay, the framers' intention for this branch, the Supreme Court was supposed to be the absolute last check. After the legislative branch has written the policy and the president has implemented the policy, it would, and there was any question about the constitutionality of it, then the Supreme Court would handle it. The Supreme Court is insulated from public opinion. They can't be voted out of office, so they have the freedom to rule without worrying about what the people want. They get to look at the Constitution and make decisions based upon their interpretation of the Constitution. They don't have to worry about what your opinion or my opinion is, and trust me, they don't care. They're safe from congressional pressure. They don't have to be reappointed, and they only can be impeached if they've done something wrong, and for the most part they don't. It's really hard to impeach a judge. I'm not saying that they haven't been. The framers didn't want them to have any power to enforce their decisions, and they can't. They give a ruling or an opinion, and they rely on the legislative branch to write their decision into law, and they rely on the executive branch to implement their decision. And that's exactly what the framers of the Constitution had intended for the Supreme Court. The framers also wanted them to be the consultors of the Constitution. Either take it word for word or look towards it as inspiration. That doesn't matter. But again, the power that was given to them in Article 3 is to interpret the Constitution. But that has evolved. Now their primary purpose has become judicial review. They are the keepers of the Constitution. They get into the mind of the framers, and they interpret based on what they think the framers would have wanted. Some judges look at law and deem it unconstitutional based on every single word they find out of the Constitution. Other judges look at the Constitution for inspiration and will decide whether or not a law is constitutional with a more flexible Constitution in mind. All of it's pretty subjective. The participants in our legal system. You'll hear us talk about litigants. Litigants are the parties that are involved in the case. The plaintiff brings the charges. The plaintiff is the first person mentioned in the name of a case. In matters of criminal law, the plaintiff is going to be the government. Like U.S. versus Nixon, U.S. is the plaintiff. They're bringing about the charges. The defendant or the despondent is the person or the party that is being charged. So, despondent is what it's called in the Supreme Court, but you're probably used to hearing it called defendant. And this is the person that has to do just that, defend themselves. Interest groups also play a role in the whole participation of the courts, or play a role in the participation of hearing court cases. They can't directly lobby judges. They don't talk to judges, so lobbyists don't go talk to judges. But what they do is they hire lawyers to take on a case, or argue a case on behalf of somebody who they believe if they win that case, that interest group's interest would be advanced. Like, here you go, Thurgood Marshall and Oliver Hill were hired by the NAACP to argue Brown v. Board, because if Brown v. Board was won on behalf of Brown, then the NAACP's policy would be advanced. Interest groups can hire lawyers, but they could also submit amicus curiae briefs. Amicus curiae briefs are friend of the court briefs. We talked about that before. Friend of the court briefs mean that they that they give information, or they file information with the court that would hurt or help a case. Okay, lawyers. You have lawyers because every citizen is guaranteed a lawyer in a criminal case. Public defenders and legal aid groups may represent poor defendants in a case. And then you have your jury. And in federal cases, there are 12 jurors, and all must agree on a ruling. Judges, of course, they're the ones that are going to be the ultimate adjudicating official. They're the ones that monitor the activities of the argument in the court and make sure all of the legalities are met and followed. Challenging the law, we have an adversarial system, which means we allow two people that have an issue to go up against each other and they will get their issue settled. Justiciable disputes, you can't just go to court because you don't like me. You have to have a good reason, and the problem that we have has to be able to be settled by law. You have to have a standing to sue. That is sufficient legal reasoning to bring about charges. Again, that goes with justiciable disputes. You can't just decide you don't like me and sue me. Class action lawsuits. This is common also for interest groups to do this, where you sue on behalf of all the citizens that might be in the same situation. Like, it's say about 500 people were poisoned by Top's Meat Company. If you want to, a lawyer or an interest group can get all of those 500 people together and they can sue Top's Meat Company as one plaintiff. Class action lawsuits were really common in the 90s with tobacco companies where smokers sued tobacco companies, and you also hear lawyers call for or run commercials. Contact us if you have been suffering from mesothelioma, right? So they're trying to get all the victims of mesothelioma together so they can file a class action lawsuit against a shipyard. Okay, so that's the intro. Review jurisdiction, that's probably the trickiest of all of it.